Okay. Okay, good evening, ladies and gentlemen. Welcome to our 27th Outright Financial Matters webinar series, a program brought to you by Finance Leap. Today, we have a very hot topic, succession planning for families. And to help us split this topic so that by the time we clock 1 hour, we are all experts in succession planning, is a seasoned senior counsel, Maxim Mutabingwa. Maxim, you are very welcome. Now, before I came here this evening, somebody asked me that succession planning is more about who and how an estate is run. And a will is about who gets what from an estate. Share us with your experience as an expert, because some of us, those are terms that are a bit tough for us. Thank you so much.
Thank you very much, Doctor. And thank you very much for inviting me. Our dear viewers and listeners, some of you may not know me. Some of you may know me. My name is Maxim Mutabingwa. I'm an advocate of the High Court. I finished school in 1996. By 1998, I had enrolled as an advocate of the High Court, and I didn't go to any other place, but I started the private practice, and I hit practice and court straight away. So I have been in court since then as a private legal practitioner. So thank you very much for inviting me to discuss this very important topic. Thank you very much.
You're welcome.
So our topic today, as Doctor says, it is a hot topic. And indeed, it is hot because it touches everybody. Nobody in this world is not touched by the topic of succession. So our topic today is succession planning for families, specifically for families. Experience, tips, and strategies. Maybe before I go further, I will first explain some important terms which touch the topic. You all know succession. Succession is an English word. Planning is an English word. And families is also an English word. But what do these words mean? I have borrowed definitions from Brack's Law Dictionary, 9th edition. And they define succession as the act or right of legally or officially taking over a predecessor's office, rank, or duties. And they go further to explain it as the acquisition of rights or property by inheritance under the law, descent, or distribution. That is how they define succession. And they also go to define a successor. Who is a successor? A successor is defined as a person who succeeds the office, rights, responsibilities, or place of another. One who replaces or follows a predecessor. So a person who follows a predecessor is called a successor. And he inherits not only rights, but he inherits also responsibilities and the place of another. And then now, about the topic. What is succession planning? Succession planning is defined as a process by which a person prepares for orderly transfer of leadership, responsibilities, wealth, property, and family values from one generation to another. That is what is defined as succession planning. So as you can see, succession planning is very, very important for families. And it is said, or it is stated that every family that owns property, it is not only the rich people. No, every person, even if you have a shirt, even if you have a button, that button may be fought for when you are no longer alive. So you have to plan for that succession early. So every family that owns property or has dependents should prepare for succession. So further about succession, a person may prepare for succession when he is still alive. Or he may prepare for succession and he writes something and it takes effect when he dies. And that is called the will. We shall come to that later. But when somebody prepares for succession before he dies, and which is very good, by the way, because a person is still alive, he determines how things are supposed to be run or managed when he's still alive and also when he's dead. And some people even go on to give out their properties, to distribute their properties when they are still alive. And when somebody gives you something when he's still alive, that property becomes yours, and it is called the gift inter vivos. It becomes yours, and nobody will ask you or will take it out from you when he is dead. And also a person can prepare for his properties, how they will be managed, his businesses, how they will be managed when he's dead. And that one is called writing a will. So a dead person can manage his properties even when he is dead by making a will. So I went on to look at family succession in this country. And very many people have been asking themselves, is family succession in this country possible? Is it possible? Is it possible to plan for family succession in this country? The answer is yes, and somebody can say no. And why do I say that? Yes, it is possible to plan for family succession in this country, but it is a very hard thing to plan for succession. What problems are faced by people who are planning for succession? What I have found out, listeners and viewers, is that the nature of our families in this country is not simple. We have a complex family structure. When a person makes a family, for example, his wedding, you see somebody who is at the altar, who is wedding, but behind in the church or at the reception, there are many others whom he is not wedding, but they are his wives also, and some have children, and some have his dependents also. So those people are always hidden, and it is very hard to disclose them when he's still alive. So it becomes very hard for such a person to plan for those people when he's still alive, because he fears his wife. If the wife knows, maybe she will file for divorce, or maybe fights may develop in the family. So what he does, he keeps quiet, and he does not say anything until he dies. And when he dies, sometimes you might find he has made a will. But in most cases, they don't make a will. Then the family now is plunged into chaos. Then secondly, you see, when you are planning, in most cases, majorly, we are planning for our properties, so that when we are no longer alive, how will our properties be managed to benefit our dependents? But what I have found out also, in most cases, many people are not sincere. They hide properties. For example, I have seen many people who are working with the government. They have many properties, but they don't register them into their own names, because he knows If they discover him, he may lose his job, or he may be prosecuted in court. They start asking him, how did he acquire the property? So what those people do, they register those properties in other people's names. So also it becomes very hard to plan for succession in that case. Then also about family, the nature of our families. Our spouses, both men and women, ladies and gentlemen, Uganda is a very religious country. But what I have come to find out for the life I have spent on earth, Ugandans, most of the people are not sincere. We are not sincere. You find somebody has properties, but he does not want his wife to know. He does not want his children to know. And this one, it happens especially to ladies. Many ladies, especially the working class, even the ones who are not working and acquire property, they don't want their husbands to know. You find she has properties, but the properties are registered in the names of her sisters or her brothers. So how do you now plan for succession of such a property, which is registered in your brother's name? Whether you are still alive or whether you are dead, it becomes very hard also. So Ugandans are not sincere. Hence, it is very hard to plan for succession, and all these problems you have been seeing, succession, court cases, it is a result of these three factors I have talked about. People are not sincere, and we don't want to plan for succession, which is very good and would benefit our beneficiaries and the other people, but we are very selfish. We don't want to do that. And that is why there are so many disputes in court. I'll give you an example. There was a very big army officer. He died. I will not disclose his name. He was so big. And what he did, he had registered all the properties, almost all the properties, in other people's names. And when he died, of course, there's nobody who came and told his wife that these are the properties of your husband. So in Unyankore, we have a problem that that those things which are hidden, they will always be eaten by rats. So ladies and gentlemen, if you know that you are hiding something, when you are no longer alive, that thing is going to be eaten by rats. You better disclose it, and then you can plan for its succession so that it can benefit your children and your dependents. Then also, why people fear to plan for succession when they are still alive. You see, ladies and gentlemen, you all know that money is power. They say that money is power. Those who with the power control money. So if somebody has his properties, he has power, he has money. And if I have money, I am controlling everything. If you are not under me, I will not give you money. If you are my child and I pay school fees, then you have to hear what I say. So I control the people using my money. That's how now, like the boss says, the boss can control you on the job because he's paying you a salary. So now what happens if I distribute my properties when I'm still alive? Then it means I'm distributing my money. And by distributing my money, it means I'm distributing my power. So if I don't have power, now I'm powerless. I'm useless. I'm very vulnerable. You become very vulnerable. Somebody can start even slapping you. Even you see in the family. That's why God made man the head of the family and gave him financial capacity to control the family. If you disturb me, I don't buy your dress. If you don't disturb me, I don't pay you school fees. So I'm controlling the family. I control society, and also you have seen in politics, those ones who are controlling the country. They have money. A person goes and buys all the votes, and he goes to parliament. So money is power. You don't have money, you don't have power. So that is a very big reason why people don't want to plan for succession when they are still alive. But nevertheless, ladies and gentlemen, dear listeners, I have seen some people who have distributed their properties when they are still alive. And when they are still alive, and even when they die, there isn't any chaos because he has distributed his properties, they benefit his dependents, and there isn't any problem. And by the way, that is the ideal. But it is not possible because of the reasons I have talked about. And I give you an example. There was a very big man who died. why people don't want to disclose. A big man died and he had a wife. And the man was very Catholic. They had 4 children. And they loved each other so much, and the man would go home by 6, he's already home. So when the man died now, on the day of the burial, another woman with 2 kids came now, who are resembling the man very, very much. So when the wife now, who was crying, saw them, now she started beating the casket of the man. Said, you, how could you do this? And actually, she wanted to remove him from the casket and beat him up. But the man was already dead. So now, what I'm trying to tell you, what if that man had disclosed when he's still alive? So that is why succession planning is hard when somebody is still alive. So that's why some people hide in wills. You make a will because the will takes effect when you die. But even some people just ignore and they don't make a will. And also, I give you an example. There was a man in Mengo. For him, he thought he was doing good, and he registered the properties in the names of the children. So that when he dies, there wouldn't be any problem. But he remained controlling them. He was getting rent from them. So when the son now grew old, he discovered that the property was discovered in his names. And the man was getting rent from it. And now there is a court case about that one. The boy went and filed the case against the man. He never contributed anything, mind you. But he learned the property was in his names. So he went and sued the man.
The father.
The father who had registered the property in his names. So those are some of the problems why people don't plan for succession when they are still alive. So succession planning, how can you plan for succession when you are still alive, or and you plan when you are still alive and when you are dead? How do you plan for succession? Very many people are interested in hearing this because there are so many problems, especially in family court. What happens when somebody dies? So it is very important to plan for the succession. And how can you plan for succession? The most viable option I have seen is that you can plan for succession, and despite all the problems I have talked about of planning when you are still alive, you can distribute some properties when you are still alive, and then you can retain some properties also, if you can. Some people have done it, and it has helped. Plan, distribute some properties, register them in the names of the beneficiaries when you are still alive, so that whenever you are dead, then there isn't any problem. Then another mode is to make a will. Some people make wills, but not many. So a will is provided for under the Succession Act from Section 49 onwards. A will, a privileged will. Section 50 of the will. Section 50 defines a will, what a will is, how do you make a will. Here I will tell you how a will is made. Some people have been making their wills and they bring them to me, to my office to witness them. So a will, in brief, you first talk about yourself, define yourself. Who are you? You are a son of who? You are a resident of where? Then, in the will, you must name your beneficiaries. Name your wife. If you have your girlfriends or anybody who is benefiting from you, name them also. Then name your children, your biological children. If you have other dependent relatives, children who are dependent on you, name them also in the will. And then after making them, so you have named your properties. You have made, also you name the properties. After the beneficiaries, then name all your properties. Even money in the bank, even the bank accounts, even the vehicles, even clothes, put them. And then after that, now think, suppose you are dead, you are no longer there. How do you want your things to be managed or distributed? Whom are you giving your vehicle? Give it there. Whom are you giving your shirts? Whom are you giving your land? Whom are you giving this land? Then after distributing all the properties, or after stating how you want the property to be managed, then I have seen some people even putting in their will how they want to be buried. Some people say, I want to be buried by the Catholic Church or the Protestant Church, even the earmark where they are going to be buried. Then after that, what people forget, very many people have made wills, especially those ones who don't go to lawyers. You make a very wonderful will. I have seen very wonderful wills. They make them, and we always meet them in court or Administrator General's office. You find the will does not provide for the what? For the witnesses. That will is not a valid will. A will has to be witnessed or attested to by at least 2 witnesses. And now, according to the amendment of the Succession Act, when you make a will, make sure that every page is signed by yourself and the witnesses, so that you confirm that that page you are the one who has made it. So after you have made that will, then the will, it is witnessed, then that one now becomes a will. But also there are still some problems. Relating the problems I was telling you, after making the will, where do you keep your will? Also, that is a big problem. I have seen it's a big problem. Because you see, Ugandans, Uganda, most of the people are not good people. They are not honest. What happens, what I have seen in some cases, a person makes a very good will. He makes a very good will, but he gives it to his friend. Then afterwards, you hear now, his friend is having sex with the widow, and now maybe it was not favoring the widow, then he will sit on it. Because he has an interest in the matter. You understand, doctor? He has an interest in the matter. So, the man keeps the will. So it is as if you have died intestate. But you died intestate and you made a very good will. But now your friend whom you gave it sat on it and now it is useless. You have not done anything. Now it means you have died as if you have died intestate. Then when you make a will now, make sure that you make many copies and give them to different people, especially people who make a will with the lawyers. I have so many wills and I have helped so many people. When a person dies, then I have to go there and I read the will. I have settled many disputes which would have arisen, but because I have somebody's will, I have to go there personally, and then I deliver the will and I read it, and then I have never made a will, and the state has a problem. Then, but also in addition to giving a will to a lawyer, you make sure that you give it to some other friends, like 2 or 3, or some relatives. And the good thing, when they bring the copies of the will, they will always be identical. So there isn't any problem. So don't make only 1 copy, because making 1 copy, it will have a problem and then it disappears. Or you find somebody trusted somebody, and then that somebody has an interest in the property. You find even himself is the one now who is stealing the property of the widow, of the children. You see, Ugandans are not honest people. Actually, I have had so many problems with Ugandans. Although some are good, but many Ugandans, about 90% are not good. And you can see the problems you are having in this country because of dishonesty. Then a will also, where the challenge is, a will, I have not told you this one, you must put there executor, executors. Executor is a person who will put your will into effect. Whatever you have said in the will, is that executor or the executors, they might be more than one or more than one. They are the ones who are going to do what you have said in the will. You understand? Yes. So, where will you get those trusted people? What I have seen, some people are put in the will as executors. But when it comes to the process of applying for probate, somebody says, he put me in the will, I'm very busy, I have my own problems, I have my own properties, I have my businesses, I have my children, I take children to school. So if I even he cannot come to court to apply for probate. So you find he relinquishes the position. You understand? So when you make a will, make sure that you get a very trusted person whom you know that this person, when you are not there, is going to help you. But don't just choose anybody. 1, don't choose a dishonest person. That person will be interested in your properties or in your widow. So don't choose him. So make sure that you choose somebody who is honest and reliable, and who is not interested in your property or in your widow. Or maybe he is interested in your widow, but at least not in your property. So how can you identify that person? That person, you know, it may be your friend, you know your friends, but some friends are not reliable. It is very hard to trace some friends also. But once you have made a will and you have provided for the executor and everything, then the will will help you. When you are no longer there, then that will be brought, and then there is a process called obtaining probate. The executors will go to court and obtain probate, and they manage your properties according to your wishes, or they distribute your properties according to your wishes. And whether you are, how many children, it will be very orderly. The succession is orderly. I give you an example. My father died. My father left 19 children from 3 wives, 3 women. 19 children. But we didn't know that he had made a will. Actually, people in the village, they were saying, hey, this family is big. When this man dies, these people are going to fight. So our father died. And we found he had gone to Mbarara, to Queensland and the company advocates, and he had made a will. And they brought a will. And for him, he had divided the properties between the wives. So wife number 1, your land is this. Because in the village, the property was run. He didn't have a bank account, no. Then number 2, your land is this. Then number 3, then he said, each child will share on the land given to his or her mother. You understand? So when my father died, for us even we never went to court to apply for letters of administration. No. Because why did we have to apply for letters of administration? What we did, we got a surveyor, and each one got an equal share with the other one, and we have never had any problem. We have never had any dispute. But now we are wondering, what if this man had not made a will? What would have happened in our family? But now our family is peaceful. There's nobody who has ever quarreled or fought with another because of the property. So that is the beauty of a will. And what I must tell you, ladies and gentlemen, dear listeners and viewers, people fear that when I make a will, I'm going to die. No, it doesn't mean that when you make a will, you'll die. There is a person who made a will. He started making a will at the age of 50, but the person died at 94. At 94. So imagine from 50 to 94, how many years are there? So it is not true that if you write a will, that you are going to die. No, you are not going to die. And you can change your will as many times as you want. After 1 year, or even after 1 week, you can keep on changing whatever you want to add. Sometimes you can acquire a new property, or you acquire new dependents. You can keep on changing your will as you want. That is what we call a codicil. So a will can be changed as many times as possible, provided you go according to the law. If a will is signed properly, is witnessed, then it is a valid will, and it will take effect after death. So maybe I leave the will, I will come back to it. There is also another mode which I have seen, which is trying to come up in this country, but because of the problems I have talked about, it is not taking root. This is the mode of trusts. People have started registering trusts because now some people have money, and they want their money to benefit their generations. Like imagine if you are owning like Speak Hotel. So if you are no longer here, what happens? How will you divide the Speak Hotel? Why can't you now register a trust to manage that property for the beneficiaries? So there are some people who have gone on to register some trusts. So a trust is registered, and some trust can take effect even before you die, but some you can specifically provide for that it will take effect after you die. So instead of distributing the properties now to the beneficiaries, all the properties, they are transferred into a trust. So the owner is not you, it is a trust. In a trust, there are 3 parties. One is the grantor, the one who has made a trust. Then the second one is the trustee, the one who is managing now. Is called who is entrusted. Then the third one is a beneficiary, the beneficiaries. So once that trust is registered, it manages the property for the benefit of the what? Of the beneficiaries. And it is very smooth. But because of what I've told you so, you see, when we don't have honest people, I think Uganda, that's why we are not developing. Because you see, if somebody cannot trust you, even he cannot give you anything, cannot give you business, now trust would be very, very good. But how many people can be trusted? You entrust him with your building, and he manages it for the benefit of the beneficiaries and not himself. What people in this country do, they look at their interest, but not the interest of the beneficiaries. So where are you going to get the reliable trustee? Where? That is the problem.
Counsel Maxim.
Where will you? So where will you get somebody who is like now, as you may have seen, you get a problem. Even getting a good lawyer in this country is not simple. It's not simple. Somebody whom you can say, I can trust, I can rely on this man. Where can you get him? I'm telling you. Some people you have seen, even we advocates, you go and collect money from a third party on behalf of your client. Instead of passing it on to a client, you eat it. And now the person was fighting with the litigant. Now he starts fighting you also. So that is where the problem is. So the problem now still comes. Where are you going to get that rival trustee who will now leave everything, and then he manages the things on behalf of the beneficiaries? That is where the problem will come from. And also, I have seen also people say, okay, now if I die, I want my children, like now I have somebody. For him, he appointed the children trustees of the businesses. He had a lot of properties. But when he died, now something happened. So then one of the boys says, I'm not interested in doing what daddy was doing. Me, I have my own agenda. Because these are his things. Me, I have mine. Said, me, I don't want to manage. Another one went to UK. You understand? Then another one went where? So in the end, there was nobody to manage. So that is also a challenge with the what? With the trusts. But by will, a person can create a trust. Whether it works or not, that is another thing. But that one is called a testamented trust. It is created by will and come into effect after the death. Now, what happens if you don't? There are other modes of succession planning, but they are not. They are not dominant. They were talking about like powers of attorney. Powers of attorney, they die when you die. When somebody makes powers of attorney can only apply when somebody is alive. When you die, the powers of attorney also die. So that one is not a good mode of succession planning. Maybe it can work. Actually, powers of attorney means you are delegating. And it happens like if somebody is in UK and wants his property to be managed here. And even some of us advocates, we get powers of attorney. Somebody is staying in America, he has properties here, he can appoint an attorney to manage the properties when he's here. But once you die, then the powers will stop taking effect. So what happens if you don't do all these ones I have talked about? If you don't plan, you don't know what is going to happen, you don't know when you are going to leave this world, you don't know when you are going to die. So what happens?
Just hold it there. Dear listeners and viewers, we are deep into succession planning. Towards the end, 15 minutes towards the end of this session, we read or attend to your questions, because I know these matters really affect all of us. So have your questions, share them in the chat room. We'll be able to have them brought to the attention of our speaker. Go ahead, the counsel.
Thank you very much, Doctor, and listeners, viewers. What I am talking about now, suppose you don't plan for your succession, you don't plan for succession. What happens if you don't have any plan? Of course, this world is not ours. One time, you will die. And death, they say, always comes like a thief. So what happens when you die? When you die, the law of the country is the one now which will plan for your succession. The law is there, it plans for your succession. How does the law plan for your succession? The law provides for how your properties will be managed and distributed when you die. Whether you die after you have made a will or if you didn't make a will. So if you die when you have made a will, that one we say you have died testate. You have made a will. So if you have a valid will, then that one, the will will take effect after you die. The executors will go to court and get what we call probate. And then they distribute the properties in accordance with your wishes stated in the will. And the will must be followed. Unless it is not valid. If the will is valid, then your wishes must be followed. That's why I'm saying that you can distribute your properties even when you are dead. So, what happens if you didn't make a will? If you didn't make a will, we say you died intestate. And the properties of an intestate also, they have a provision in the Succession Act. How are they distributed? Then there, the law provides for percentages. The law provides for percentages. And that is Section 23 of the Succession Act. Section 23 of the Succession Act, without reading the whole of it, where the intestate is survived by a spouse, a linear descendant, the linear descendants shall receive 75%. So the law provides for how your property, now it plans for your succession. The law plans for you instead of planning for yourself when you are still alive. So if you want to get the particulars of how your properties will be managed and distributed when you die, then you go to Section 23 of the Succession Act. It gives the provisions. But there are so many problems, and this is now why you must plan for your succession. Whether the law plans for you, there are some costs which you have to incur, but you will be dead, but which your beneficiaries will you have to meet. The first problem is now. I talked about the nature of these families. You find somebody has a wife, has a girlfriend, has multiple partners. The children, they were not known at the time of his death. So how will those people now come to a meeting and agree on the what? On the administrator? How will they come and agree? I handled the dispute in Mbarara. A Hajj had died. A Hajj had I think 69 children. And we had lodged the case in court. All of them came to court. Some came with sticks, some came with pangas, and they were ready to fight. But I called them, I used my skills, and I mediated the dispute, and we settled it amicably out of court, and everybody took what was due to him or her. So it is very hard for now the people now to appoint an administrator, to agree on somebody to be appointed as an administrator. And by you people, you think that when you have one wife and children of the same father and same mother, they cannot fight. Those are the people who fight most, I'm telling you. Same father, same mother. There is a man who died in Ntungamo. And for him, he had planned for succession. He said, now if I'm not there, let me register the properties in the names of my wife and myself. So they had joint properties. Now, what happened? The man didn't die, but the wife now died first. When the wife died first, the children of the same mother, they said, some of them now said, now the father is about 95. They said, now our mother has died. Can you give us the properties of our mother? Because these properties, they are registered in yourself and our mother. So now we want the share of our mother. Then when you die also, we shall divide our share. Then the man said, over my dead body, I cannot give you my properties. They said, no, this is not your property. It is our mother's property. It is registered in her name, and you also have your share. Now they are in court in Mbarara. You understand? So that is one of the problems people face. Also, then another thing is what I had hinted on. You die suddenly. You had hidden not only the children, but you hid the properties also. So how will those properties be planned? Somebody is in the name of, I mean, some properties are in names of third parties. And even people, you told people that this is my property, but it's not in your names. And now you are left at the mercy of that person in whose property you had registered the what. Then what I have seen also, many people don't register their properties. Somebody buys land, he is given transfer, he is given a title, he keeps it in his drawer. You find he does not register. So then he dies. Then you find even the name of the person in whom it is registered, he also died. So you find you have property there, but ownership becomes a problem. How will you trace now the former owner? It becomes hard. People, whether deliberately or not, they don't want to register the properties. Especially those people who are working with government. They don't want to be known. They don't want to be known so that they don't lose their jobs. Then also, if you don't want to plan early, you have seen nowadays, DNA is becoming very prominent. So a person dies, left the children, then left other children and other children from multiple women. So now the issue is, who are the children of the deceased? Are they the children who resemble him or children who do not resemble him? And in most cases, he will not have introduced them to the family. So who is going now to benefit from the property of the deceased? You have had the recent case of Bob Kafero, the singer. 25 children were subjected for DNA, but only 4 came out as his children. You understand? So what if you find your DNA does not rhyme with the deceased? Then you are thrown out. You understand? So, but once you have made the will and you have provided for that person, nobody can throw him away from the will, because you have provided for him in the will. So that is the most beautiful thing with the will. Whether the person was your son, your child or not, then once you have provided for him, then the will must be followed. So that's why a person should make a will. DNA, people fight.
Time is always not enough. We are 14 minutes to the end of the hour.
So then maybe you can take some questions.
Can I give you 4 minutes?
Yes.
And then you explain what you want to explain, then we go to questions. So
now what I must tell you also, why you should make a will or why you should plan for succession. Even when somebody dies, then the process of getting letters of administration is not simple. It is always very, very, very hard. I have told you one of the problems, identifying the administrator. Then you have to start from the office of the administrator general. And you get what we call a certificate of no objection. You see, when somebody dies intestate, in the real sense, it is the administrator general who should be managing his property. But because the administrator general also is understaffed, then he gives permission to the beneficiaries to manage. But now you have first to apply to him for what we call a certificate of no objection, that he does not object to you administering the property. So you first go to administrator general. And people, that's where the fighting is always. Then after that, you petition court. The fighting continues in court also. So it takes long, and you find somebody left money in the account, on the account, and that money cannot be accessed. Somebody left property. Even by then, you cannot collect any money from a tenant because you are not the administrator. The children who are studying, they cannot get school fees. You understand? So those are the problems of lack of planning. That's why somebody should always plan so that all those problems do not come up. And you have seen a person is rich, he dies, but there's no money for school fees as they are fighting in court. So the children, they get out of school. So those are the effects of lack of planning.
Good.
Then also, I would urge the people, the listeners, our viewers and listeners, plan for succession. If you can, disclose your women, whether they are multiple, disclose them. But I know many people are scared of their wives, so that their families do not break up. But then in that case, make a will or make trusts. Because death comes like a thief. You don't know when you will leave this world. So it is always very much better to plan for your succession. Thank you very much.
Thank you very, very much, Senior Counsel. And I think we are privileged and honored to have had you this evening. Now, this is the time our audience, and we already have a number of questions. The first question, Counsel, is that somebody has money in the bank, and death steals him, like you have said, and that money cannot be accessed. Are there any mechanisms that one can live while still alive that can allow that person to actually access the money through the beneficiary he has defined to access? That's the first question. The second question is that where a couple has property in the names of both spouses, the wife and husband, do they need a will? Because the property is to those and their children. The third question is which spouse is defined in the Act as the rightful spouse? Is it the one legally wedded for the family where they are Christians, or it is any? It also extends beyond that boundary. And what are their benefits for the legally wedded spouse? We have focused more on when the man dies first. One is asking, what about where the woman dies first? Does the woman also make a will in a family? Would that will also be respected? That is the other question. You can first take on those, and we see how time behaves with us.
Thank you very much, Doctor, and the listeners and the viewers. The first question: money is in the bank. Somebody holds money in the bank. The account is registered in his name, and he dies. So, how can the beneficiaries benefit without first passing through the process of applying for letters of administration? That is your question, isn't it?
The question is, yes, what mechanism can he put in place to make sure that that money, in the unlikely event that he dies, can be accessed even to help him in his burial?
Yes, in his
because he can die abruptly, and that money may fail to be accessed.
Yeah, that is very good. So there is no way how that money can be accessed after somebody dies. If the account was registered in his own names, in his own name, when he dies, then there is nobody who can withdraw that money, except, and I want you to hear me, except you can circumvent that by opening an account. As in the names of joint account. So if, Doctor, you had opened an account with Mutabingwa, and if God forbid I die, and you are a joint owner, you have a right of running the account. And even you can go, you get money for school fees, even you get money for my burial, everything. So that is how you can beat that one. But if you are a sole signatory, nobody, actually, by the way, Doctor, nobody is supposed to know the amount. You first go to court, apply for letters of administration, and then you take them to the manager. And then that's when they will show you the money which is on account, how much was. Then couple has property registered in joint names. Do they need a will? So a couple can be registered on the property in two ways. One, they can be registered as joint tenants. Two, they can be registered as tenants in common. Tenants in common means they have equal and divided shares. So there, it means you will need a will. because the wife owns a part, but is not divided, and the husband also owns another portion. So if somebody dies, then the beneficiaries of that person, they are entitled to his share or her share. You understand? But a couple may be registered as joint tenants. Like now I'm handling a case about joint tenancy. They were registered as joint tenants, and they divorced. They divorced, I think, in the 70s, before even I was born. And now they are in court. So it means once you are joint tenants, no survivorship. The person who dies leaves all his interest to the other one, the surviving one. So now it is now the beneficiaries of the surviving spouse who will take the shares. The children of the one who has died, they are not entitled. So if your husband and wife have land, and it is registered in the names of the husband,
of the husband,
and wife. Like in the other case of Ndungama, I told you, it is joint tenancy. The wife dies. Then it means the land was left to the man. But we told the children, they don't understand. I don't know which lawyer they went to, but you should have told them about joint tenancy, no survivorship. That is a very good thing. And there you don't need a will. You said about the rights of spouse over what? How many, I mean, wives, marriage. Who is a spouse, isn't it? Who is a wife? You see, in Uganda we have 4 laws which govern marriages. One, we have the first one called the Customary Marriage Registration Act. That one is where a person marries according to the custom. And that one is potentially polygamous. You can marry as many wives as you want, and all of them are equal. You marry and you put there. You marry another one and you put there. You marry another one. Whether you have 5, you have 5. Those are your wives, and all of them have equal rights. You understand? Then there is what you call marriage in accordance with the Marriage Act. That is very dangerous. If you marry and you wed according to the Marriage Act, I mean like these people who wed in church, then it means you can only marry that person only. And once you have married him or her, the law does not recognize any other marriage you enter. They say it is null and void. But I have seen people, you see, Ugandans, after wedding, he goes and introduces another person and pays dowry, and then introduces another one. That one is null and void. In law, that one is not recognized. So when he dies, that one cannot benefit. He doesn't have any benefit. But her children can benefit. And her children have the same and equal rights like the children of the wedded wife. Then also we have Mohammedan marriages, which are also polygamous, the marriages of Muslims. And also we have the marriages of Hindus also. But now the most important role here, because most of the percentages of the people in Uganda, they are Christians. And they marry according to the Marriage Act in the church. You are allowed to marry only one person. Once you have wedded that person, no any other marriage of yours is recognized by law. And upon your death, they count only that person who wedded, and all the others, they are called girlfriends, so they are called concubines. They are not recognized by law. So the widow will take her 20%, the whole of it. All the others are not widows. Then you are asking, what about if the woman, it is the woman who has died first, and the man has survived the woman. It is the same law. If the woman has property, then of course she will have. I don't think there is any person who doesn't have a property. Even if it is a dress, she's supposed the beneficiaries. If she didn't make a will, some people die when they have made a will. But if she didn't make a will, then number one, beneficiaries now reported death to Administrator General. Then Administrator General holds a meeting of the beneficiaries to appoint somebody who is supposed to be appointed as an administrator. Then an administrator is appointed, and then the estate of the deceased is distributed in accordance with the law, with what I told you in Section 23 of the Succession Act. Yes.
Time is not our friend, but this one I will not leave it. I know there are going to be discussions tonight in a number of people that are listening to us. What would be the things that you would guide them to focus on in the discussion this evening around succession planning to start off in terms of the discussion, because it's a critical subject? Thank you so much.
Thank you very much, Doctor. That question is very hard because it mostly depends on the character and the socio-economic circumstances of this country. And actually, I have talked about it also, because it is the idea everybody should plan for succession, because we don't know when we are going to die. And as I have told you and the viewers and listeners, there are so many advantages when you plan for succession. But if you don't plan, there are so many problems. For example, if you can disclose your dependents, for example, like your wife knows all your children, including the children who are with multiple women, that one would be very good. Because when you die, the wife will say, and her kids will say, we don't know these people. We don't know these people. So they will start fighting. So why can't you disclose your dependents? That's the number one. Why can't you disclose your properties so that your family knows, the members of your family know your property? Other than hunting, then they start looking. Then another thing I have not talked about, make sure that all the documents relating to your properties are available. Like you have a drawer, all your titles are there. You understand? But like somebody dies, now they are in the house, they don't know where the title is. What is the title? Is it with the money lender? Is it in the bank? Why can't you make like a safe and maybe your wife? But you see the problem now. This one I'm seeing it in family court. Spouses they don't trust each other. They don't trust each other. You see houses there. You see a home. There is a man and a woman whom we call wife and husband, but they are no longer sleeping on the same bed. This one is doing his business. This one is doing his business. So how will he disclose the titles now? It becomes a very big problem. So in that case, that's why in this country, a will is the most viable option. Because you write your thing, you want how your properties will be managed and distributed when you are no longer there. Then this will speak upon your death. But if you can do it when you are still alive and you disclose everything, disclose your properties, disclose what your plans. I have seen some people. He has house there was a lady who had rentals. The lady had rentals. Even I think she's still alive, but I was managing them. But she didn't want her husband to know, and she was getting a lot of money. Many women get a lot of money, but they don't want the husband to know. Me, I was managing and collecting money and giving her, because I have a fiduciary duty not to disclose. So now, if that lady dies now, what will happen to the apartment? They will be eaten by the rats. So that's what I was doing. So if you cannot disclose, listeners and viewers, this is my final remark. If you cannot plan for succession when you are still alive, you fear maybe your spouse, you fear your husband, then it is better to write a will. A will will speak after you have thrown away, when you are no longer in the life of this world. Thank you very much.
Thank you very much. Normally, every last Wednesday of the month, we have these hard conversations about finances, about things that affect all of us. Next month, which is 26th of August 2026, we'll be having another hot topic around agricultural investment, challenges and opportunities. See you then. Thank you so much.